Hello, this is R.J. Deacon, reading the Supreme Court of the United States opinion syllabus in Lagos versus United States. Certiorari to the United States Court of Appeals for the Fifth Circuit. Argued April 18, 2018. Decided May 29, 2018. Petitioner Sergio Fernando Lagos was convicted of using a company he controlled to defraud a lender of tens of millions of dollars. After the fraudulent scheme came to light and Lagos' company went bankrupt, the lender conducted a private investigation of Lagos' fraud and participated as a party in the company's bankruptcy proceedings. Between the private investigation and the bankruptcy proceedings, the lender spent nearly $5 million in legal accounting and consulting fees related to the fraud. After Lagos pled guilty to federal wire fraud charges, the district court ordered him to pay restitution to the lender for those fees. The Fifth Circuit affirmed, holding that such a resolution was required by the Mandatory Victims Restitution Act of 1996, which requires defendants convicted of certain federal offenses, including wire fraud, to, among other things, reimburse the victim for lost income and necessary child care, transportation, and other expenses incurred during participation in the investigation or prosecution of the offense or attendance at proceedings related to the offense. 18 U.S.C. 3663 A. B. 4. The Supreme Court held, the words investigation and proceedings in subsection B.4 of the Mandatory Victims Restitution Act are limited to government investigations and criminal proceedings, and do not include private investigations and civil or bankruptcy proceedings. The word investigation appears in the phrase, the investigation or prosecution. Because the word prosecution must refer to a government's criminal prosecution, this suggests that the word investigation refers to a government's criminal investigation. Similar reasoning suggests that the immediately following reference to proceedings refers to criminal proceedings. Furthermore, the statute refers to the victim's participation in the investigation and attendance at proceedings, which would be odd ways to describe a victim's role in its own private investigation, and as a party to in non-criminal court proceedings, but which are natural ways to describe a victim's role in a government's investigation and in the criminal proceedings that a government conducts. Moreover, the statute lists 3 specific items that must be reimbursed: lost income, child care expenses, and transportation expenses. These are precisely the kind of expenses that the victim is likely to incur when missing work and traveling to participate in government investigation, or to attend criminal proceedings. In contrast, the statute says nothing about the kinds of expenses a victim would often incur during private investigations or non-criminal proceedings, namely, the costs of hiring private investigators, attorneys, or accountants. This supports the court's more limited reading of the statute. A broad reading would also require district courts to resolve difficult, fact-intensive disputes about whether particular expenses incurred during participation in a private investigation were in fact necessary, and about whether proceedings such as a licensing proceeding or a Consumer Product Safety Commission hearing were sufficiently related to the offense. The court's narrower interpretation avoids such controversies, which are often irrelevant to the victim because over 90% of criminal restitution is never collected. The court's interpretation means that some victims will not receive restitution for all of their losses from a crime, but that is consistent with the Mandatory Victims Restitution Act enumeration of limited categories of covered expenses, in contrast with the broader language that all other federal restitution statutes use. See 18 U.S.C. 2248b, 2259b, 2264b, 2327b, that the victim shared the results of its private investigation with the government does not make the cost of conducting the private investigation necessary. Other expenses incurred during participation in the investigation of the offense 3663A-B4. That language does not cover the costs of a private investigation that the victim chooses on its own to conduct, which are not incurred during participation in a government's investigation. The decision is reversed and remanded. Justice Breyer delivered the opinion for a unanimous court. Thank you for listening.